So I would try to do anything that I could to maybe do a consent modification that we talked about earlier to try to save on litigation costs. But if not, try to get into court and file the motion to modify, just because I don't believe that since the two of you have been legally divorced, the two of you should reside together, especially in the best interest of your child.
And I'm sure the modification suggestion, which is a great suggestion, isn't exactly what you want to hear, considering according to the facts that we have before us, it was just finalized October 8th, which was, not that far away. But again, just because you're divorced, and this goes for either party, you don't have to let the other party rule your life anymore. Yes, do you have to communicate if you have children in common? Absolutely. However, there are ways to mitigate one spouse or one ex-spouse treating the other ex-spouse in ways that they treated you during the time they were married. I mean, once you are divorced, the control should stop. And there are ways, if you really sit down and think about it, to keep that control from happening and letting that other person rule your life. Again, if you're arguing in front of your 18-year-old, just stop yelling and go downstairs, or stop yelling and leave. I mean, obviously, again, the best recipe in this case, even if you don't do the modification, is to borrow money, ask a relative, move somewhere else if at all possible. I know that may not be the ideal answer that you want to hear, but getting one of you out of the house to have a better quality of life perhaps is a better situation. And
you raised a good point as far as mitigating. If you do have to reside together, and this is court order that's forcing two of you to reside together, you don't want to file a modification for whatever reason, I think it is a good idea to help mitigate some of the tension between the two of you in the household by partitioning off some of the house. I mean, at least that way it'll somewhat appear as two separate and distinct households, even though you're residing under the same roof.
Right.
I'm going to move on to our next question here, which is something that, again, we deal day in and day out, since we primarily represent men, and coming in dealing with a maintenance or alimony claim. Wife is going to claim that she is not working or working at minimum wage and for part-time, and that's what should be imputed to her. And this particular question, that person presenting the issue states that he has evidence that wife is making $40 an hour. And even more so, he's got evidence of the fact that wife has spent the money that he's been paying her on for the children on 2 new cars, $40,000 on plastic surgery. And so what this particular person is looking to do is a modification. And just looking at the question on its face, I definitely think that this person is a candidate for modification. I would suggest that you seek an attorney in the state of Florida regarding what the actual what you need to prove to the court in order to seek judicial intervention for a modification. But if we were here in Missouri, I would think that this particular person would be a good candidate. You would definitely want to bring in, when you talk to your attorney, the records of where the money that you've been paying in child support is going. Apparently, according to this particular question, it's not going for the benefit of the children. How does 2 new cars and plastic surgery benefit the child?
Well, and that's my first question with regard to this case. Question is, the person that posed the question didn't really specify whether it was maintenance or child support. I think either way, if we're talking about maintenance or child support, you're probably qualified for a modification, provided your divorce decree, if it is maintenance or alimony, whatever your state calls it, doesn't preclude, or provided the provision that you agreed to didn't say that this is a non-modifiable provision. Again, you'd have to look at your state-specific rules with regard to maintenance or alimony. However, I think, again, if we're talking about child support or we're talking about maintenance, most certainly I think a modification is in order. Clearly, if they imputed her at, again, the question states $6.25 an hour for 20 hours a week, and now you believe she's making $40 an hour cleaning houses and she has quite a few clients, clearly that is a great jump in income with regard to changing it for maintenance or for child support. The only problem you may run into is being able to get those records, being able to prove if she is self-employed, how much money she actually does make to make your case better. I think that, again, this question says that the court order is about 7 years old. So again, are you within the year range to have a modification if there is a year range? Absolutely. In Missouri, obviously, there has to be a substantial and continuing change. Most certainly under Missouri law, you would, qualify for a modification. But again, in thinking up your case, You need to think about how are you going to get the records to prove not only the plastic surgery or that she used the money for cars, but more so, how do I prove what's going to benefit you in the long run is how do I prove what she's currently making, which will obviously change my financial obligation, and how to go about getting those records without her hiding them, or if she is self-employed, being able to hide the records, or to not, if she doesn't claim it all on taxes, or to do whatever. I mean, obviously, people that are self-employed, it's not as easy as just sending a subpoena and getting normal course of business records. So that's probably the only catch-22 in this question that I see with regard to doing a modification of maintenance and or child support.
One of the things that sticks out when I read the question is there's a mention that mom went to school. It doesn't say if she received a degree, if she's currently still in school, but this person could be a candidate for a term maintenance, or just in general for callers or people who have tuned in on DadsDivorce.com listening to us. If your wife is currently in school, you may be a candidate for term maintenance. At least here in Missouri, the fact that that's one of the under the statute, that's one of the things that the court can use in order to term maintenance is dependent upon, the length of the marriage and certain other factors that are enumerated under the statute. But how long will it take for mom to get her degree, and what degree will that be, and what will the income be from that degree? And that may be use of getting an expert involved. But let's look at this question. That's something that you may want to take into consideration. As Heather mentioned, on coming back on a modification. If mom has a bachelor's degree and she's earning an income, well, that's going to be probably most likely higher than at $6.25 an hour when the decree was already entered. So that's something else you want to take into consideration as well.
The only side note is think about yourself, though, with regard to not so much maintenance, but more of a child support case, depending upon how your state figures child support. If your income has increased exponentially since the years of your divorce, you need to take that into consideration and possibly talk preliminarily with an attorney about how that affects if it is a child support modification, because if you are earning quite a bit more money than you were at the time of the divorce, and she is too, it may all come out in the wash. It may not be worth actually filing, anything with the court in the long run, because when you open yourself up to filing a motion to modify, obviously, at least in the state of Missouri, cross motions can be filed and whatnot, and the judge is not only going to look at, okay, hey, she went from $6.25 an hour to $40 an hour, which is a great increase, but dad or whoever else, have you gone from making $50,000 a year to $200,000? And if that's the case, maybe you need to be paying more in child support, which obviously we don't want to touch that with a 10-foot pole if you're the person posing the question.
Right, you put yourself at risk for potential exposure to an increase in child support and or maintenance. However, looking back at what the decree would state, the decree is probably based upon what reasonable expenses are, and what would be in your favor in this current instance would be the fact that ex-wife has bought 2 new cars and had tens of thousands of dollars in plastic surgery. Are those considered reasonable expenses?
Reasonable, and as Dan mentioned originally, for the children. I mean, if mom needs a car, is that something that child support can go for? Does it seem fair? No, but some judges will say the kids have to be transported. But 2 new cars and some plastic surgery, again, I don't know how that benefits the children.
Right. Well, unfortunately, we're out of time tonight. Appreciate everyone tuning in and sending in their questions on Ask a Lawyer. Heather, thank you very much for joining us. Appreciate you taking time out of your busy schedule to join us this evening. If you have other questions or want some follow-ups, please log on to DadsDivorce.com, click on Ask a Lawyer question, submit it, and we'll try our best to get all the questions answered in a timely fashion. Please continue to check our website daily as we're continuing to update it with new information regarding state laws and modifications and new things that are happening within the firm. Again, that's DadsDivorce.com. Thank you.
Thank you.